What a small, select, charming little group we are to discuss a topic that could be, it could feature quite high in news media later, because I think it's an issue that the public will actually care about. This bill has rightly been recognised for its proposed duty of candour, but there's another provision within it, less understood and yet actually vastly more consequential: the creation for the first time in modern democratic history of a criminal offence of misleading the public. It provides that where a public official, including our very own Prime Minister, knowingly or recklessly deceives the public on a matter of significant public concern, and if that deception is proven to the criminal standard, a prison sentence of up to 2 years may follow. In short, the Prime Minister is proposing to criminalise lying in politics for the first time, and he's leading by example by applying it to himself. This has never happened before, and I do congratulate the government for being brave and decent enough to criminalise lying by their own ministers. I think that's a very big step. Now, this bill has commonly been called the Hillsborough Law because of the stadium crush in 1989 in Hillsborough, Sheffield, in which 97 Liverpool supporters were unlawfully killed, followed by years in which police and other officials advanced misleading accounts that falsely blamed the victims, deceived families over the pain their loved ones suffered before death, and obscured institutional failings. The sustained campaign by the bereaved families for truth and accountability led to the Hillsborough Law Now movement and to the introduction in Parliament of this bill. It is intended to impose a duty of candour, a statutory duty, and criminalise serious deception by public officials. It's worth noting that the inaccurate account by Sheffield Police has never been corrected, and that is something the government should resolve. Amongst others, the Hicks family lost 2 daughters, and they and other still grieving families deserve the truth. This bill will correct an inconsistency. For centuries, we've criminalised deception in almost every professional sphere, except for some politicians. Fraud is an offence, perjury is an offence, false advertising is unlawful. Under consumer protection legislation, tradesmen may not mislead the public about serious matters. In finance, in commerce, in the courts, in taxation, truthfulness is not optional, it's legally enforceable. We already accept under the Representation of the People Act that dishonest statements about a rival candidate during an election may be criminal. So the principle that deliberate political falsehoods can be legislated against isn't novel. It has existed for decades without overwhelming the courts or extinguishing debate. No equivalent statutory standard has governed broader public claims made by politicians. That anomaly can be set against the collapse of public trust. The Ipsos Mori Veracity Index once again ranks politicians amongst the least trusted professions in the UK. That distrust weakens democratic consent. It discourages civic participation. It feeds a corrosive cynicism that democratic institutions cannot be trusted and that Parliament is full of liars. It makes the lives of members of the Commons and the Lords much harder and doubtless impacts on our well-being as well. But this bill does offer some hope. This proposed new offence of misleading the public attempts to respond to that crisis, not by criminalising opinion, not by silencing debate, not by punishing error or failed prediction, but by addressing something narrower and more serious: deliberate or reckless deception about matters of significant concern to the public, proven beyond reasonable doubt. Some have raised concerns about free expression. Those concerns deserve respect, but the offence, as drafted, is confined to intentional or reckless deception. It does not criminalise political disagreement. It does not capture advocacy. It does not police rhetoric. It does not apply to anything said within Parliament, as privilege is still in place. It only targets proven deceit elsewhere, such as online, on television, on radio, and at events. And I hope that this narrow definition will stop people with expensive lawyers from launching malicious legal cases in the hope of silencing legitimate criticisms. In short, this provision affirms a simple democratic proposition: those who exercise public authority should not be permitted to lie to the public with impunity. So far, so good. And yet, the following exemptions have been brought to my attention by campaigner Marcus Ball of Exec, who is working with Jennifer Nadell of Compassion in Politics and with Luke Meyer MP from the other place. As currently drafted, that proposition excludes some parliamentarians. Civil servants would be bound by this, police officers would be bound, members of the armed forces would be bound, NHS staff would be bound, and government ministers, even the Prime Minister, would be bound. But backbench members of Parliament and members of your Lordship's House would not. The shadow cabinet would not. The opposition in its entirety would not. There may be procedural explanations for excluding peers and backbench MPs, or there may even be technical constitutional arguments, but I just wonder what the public is going to think. They will see a law that criminalises deception by nearly every category of public official, except the very people who are making this bill become law. They will not be persuaded by constitutional nuance. They will draw a much simpler conclusion. If Parliament legislates a requirement not to lie for others while reserving exemption for itself, the perception will be that we parliamentarians are hypocrites. That perception will endure each time the offence is invoked, each time a prosecution is considered, each time accountability is pursued, each time any parliamentarian is accused of being dishonest. The public will be reminded that Parliament chose to criminalise lying by almost all public officials apart from themselves. Equality before the law is the foundation of democratic legitimacy. If nurses, teachers, civil servants, ministers, even the Prime Minister, are to be subject to this standard, it's impossible to persuasively justify a position in which members of either House of Parliament are not. Surely those who make the law should be subject to the same standard of honesty that we, as legislators, impose on others. This House has long seen itself as the guardian of constitutional principle. We are uniquely placed to consider not only how legislation functions in the courts, but how it will be understood by the public. I'm concerned that if we don't apply this law to ourselves, we will be causing reputational self-harm. We are legislators, we pass laws that relate to everyone else, so why not to us as well? To conclude, I would like to ask the Noble Lady the Minister a couple of questions. I sense the government probably won't accept what I'm saying, but I wonder if she would meet me at a future date to discuss this, perhaps with one or two lawyers along who can argue more persuasively than I can. But I do want to ask why members of Parliament, in both houses, are excluded from Clause 11. And will the government now give serious consideration to removing that exclusion so that this bill may stand as a testament to integrity rather than a monument to hypocrisy? I beg to